bench of the top court gave a unanimous verdict today that held the compensation paid to landowners at the government treasury completes the land acquisition process. Now, this decision has reversed the 2014 verdict, which said that the payment has to be made in court. Land acquisition lapsing can only take place when compensation has not been paid and possession has not been taken, and that is pending in these proceedings. So it has to satisfy both of those conditions in order for it to be called a lapse. Our correspondent Vaidyanathan brings us the key takeaways of today's verdict.
A five-judge constitution bench headed by Justice Arun Mishra today delivered a judgment on the land acquisition issue, which has been pending here in the Supreme Court, which led to some controversy also. What is the case about? What are the important points? Will it help the landowners or the government? We are joined by Mr. Batra, who argued for one of the petitioners. To make it simple for a common man, what are the key takeaways from the judgment?
In fact, this controversy has been around for a long time, since the time 2014 Act came into existence. And post that, there have been numerous judgments which have laid the law on this. But now there was a constitution bench which was constituted of 5 judges led by Justice Arun Mishra. Justice Arun Mishra has now interpreted Section 24. And while interpreting that, on 6 issues, law has been laid down. And it has been said that, in fact, the payment which is made in court will not only constitute payment in the treasury will constitute payment as well.
So does it mean the 2014 judgment given by Justice Lodha, Lokur and as well as Mr. Kurian Joseph is reversed?
The Pune Municipal Authority, which held ground till now, has been overruled by the Constitution Bench. And in fact, it has been said that both the conditions, possession and as well as non-payment of compensation will have to be there, in fact, if the land has to lapse, if the acquisition has to lapse.
So does it mean, is it in favor of the government or is it in favor of the landowners?
No, it's completely in favor of the state government, because it leaves the very little ground, very little space for a landowner to claim lapsing of acquisition under the 2014 Act. In fact, earlier what was laid by in Pune Municipal Authority said that, in fact, if one of the conditions is fulfilled by the landowner, then it will constitute lapsing.
So what is the change now today?
Today the change is that it has been said that the word which was used in the section or will now has to be read as and both the conditions, non-payment of compensation and non-taking over of possession, have to be proved to claim lapsing of the acquisition.
Let's get you an update from the state of Madhya Pradesh. The political battle over alleged horse trading in the state has turned into a full-fledged war with one of the Congress MLA from Suva